Hello, good evening. This is Beck from RCB Mediation Services, and welcome to tonight's event, Ready to Mediate, Prepare for Family Law Mediation. So I think we just have a few people still joining us. So while they're doing that, I'll just go through a few housekeeping matters. So we do have the Q&A facility tonight. So if you have any questions that come up or comments that you want to make as we proceed, please do use the Q&A function, which should be visible there in your window. And I will keep an eye on those and I will do my best to answer them. If I don't get to your question or comment tonight, then I will do my best to respond in the event in the next 24 hours. So keep an eye on the event notifications and I'll get back to you that way. So a few more people just joining, so we'll just give them a moment. In case you missed it, my name is Rebecca Carroll-Bell. I am the Principal Mediator at RCB Mediation Services, and I am the Chief Conflict Resolution and Prevention Strategist. So we'll just give it another minute for the last few people to join us. You'll see down the right of the screen, I've shared a couple of links there. One is a link to my website where you'll find a lot of information and free resources, and I am updating that regularly. And you can also subscribe to my Everyday Mediator blog via my website, and that's a great way to keep up to date with the latest offerings and resources, as well as with news, tips, articles and advice about mediation. A little bit about me before we get started. I practice in a number of areas of mediation. I have particular focus on family law, magistrates court matters, on estate law, so that's deceased estates and conflict over deceased estates, and an area that we call elder mediation and elder law, and that's helping people to resolve issues that are arising in the context of aging. So I think that we'll get started now. That's given everyone a few minutes to jump on board, and if anyone else comes along, they can join us as we go along. So again, good evening. Welcome to Ready to Mediate, Prepare for Family Law Mediation. We are live to air tonight, and this is being recorded. So the recording will be available via YouTube probably sometime next week. I'll probably have time to edit it over the weekend. So next week you should be able to access this if you want to listen again or share it with friends, family, colleagues. I'd like to acknowledge some support that I've had this week in getting ready for this webinar and in promoting it and getting the word out. Divorce go-to girl, Renee Williams, who will be our special guest next month. Andrew Cooper from Advice for Living. And Margaret Hyatt from from Speaking. Oh, goodness me. Margaret, I'm so sorry, but the name of your business has completely fallen out of my head. So Margaret Hyatt, you can find her on Facebook. She is wonderful. And Melanie Taylor from Success on Purpose. So thank you very much to all of you for your help and support in getting this event together and spreading the word amongst your people. So we are law mediation, and as I said, it's one of several areas that I practice in. And it's a bit of a path I've taken to get here. I started out actually working as a lawyer, and when I started working at my first law firm in 2001, ADR, which is variously stands for appropriate dispute resolution or alternative dispute resolution or sometimes amicable dispute resolution. Anyway, when I was starting out almost 15 years ago, it was seen as very alternative. It was almost seen as something that you did instead of going to see your lawyer. And over the last 15 years, that's evolved and changed, and mediation has grown as a profession here in Australia. It had been quite well respected and widely used in the UK and in the USA for a long time. And really, thanks to the efforts, I think, of the family law sector, it's been brought into the mainstream legal practice here in Australia. And in fact, it is now compulsory to attend a mediation in most jurisdictions in Victoria and in the family law jurisdictions, basically the judges won't give you a trial date to go to hearing until you've at least had a go at mediation. So I worked for over 10 years as litigation, or in litigation law, as a lawyer. I worked in personal injuries, I worked in family law, estate litigation, a bit of employment law, lots of different things, lots of interesting cases. And as I said, I saw mediation evolve over that decade or so into something that was quite different from what I first saw. When I first started working in the legal industry, the mediator's role was very limited. They basically were holding the room so that everyone could go off to their separate rooms, and the lawyers and barristers could shuttle back and forth in between. And mediators really, in my experience, didn't do a lot to advance the cause. When I was working for state trustees, I had the opportunity to spend a lot of time in mediation and to work with a lot of fantastic mediators here in Melbourne. And I saw mediation begin to bring fractured families back together and help them to create strategies to coexist in the world. And often these people were grieving. They were often involved in an estate dispute. They were often fighting over a deceased loved one's estate, and the grieving was very raw. And in fact, even though the loved one may have died a year or two ago, they were still stuck and caught in that grieving process because they can't move on until until the dispute over the will has been resolved and all the property realised and distributed. And I think much the same thing can be said of family law as well. Often you're so caught up in the grieving, but you can't move on and out of grieving until you've sorted out the settlement. So whether that's a property settlement or sorted out what's happening with the children. So as I said, I was working at state trustees as a corporate lawyer, and I really did fall in love with mediation. It had been on my radar for a few years. It was something that I had wanted to explore a bit more. And so when the opportunity train as a mediator, I take it. So I handed in my notice and walked away from a permanent ongoing job so that I could qualify as a mediator and start my own practice, which has been a wonderful experience. And as I've found my way through the world of mediation, no longer having the safe harbour, as it were, of the full-time employment, I noticed that many people are now accessing free and low-cost mediation and conciliation, whether that's in the family court or in work cover or in Fair Work Australia or VCAT. And indeed, a lot of the courts now offer free mediation or conciliation, or sometimes it's called something else. But essentially, it's a dispute resolution process where the parties come together to try and resolve the dispute without someone making a decision and imposing it on them. And here in Victoria, some of these ADR options, parties can bring a support person with them, but the parties are discouraged from, and in some cases not permitted to have their lawyer with them. Even where they are allowed to have their lawyer with them, the cost can be prohibitive. And I was getting a lot of inquiries around these types of matters where people are saying, oh, I've got a friend who's going to a mediation or going to a conciliation, and they need a little bit of help. They need someone to help them through the process. And so I decided that I would expand the services I offer to include conflict resolution coaching, mediation coaching and support. And I now attend mediations, conciliations and VCAT hearings as a support person for those clients who don't have anyone else that can go with them or can't afford to have their lawyer there, or perhaps their lawyer is not permitted by the system to be there. And I find it's very rewarding because often, and as a lawyer I know I did this a lot, when you are approaching a matter as a lawyer, you are looking at it from a very analytical perspective, and you're looking at it and you're thinking, what is relevant, what is admissible, what do the rules of court say, how have I been trained to approach this? And I've noticed as a lawyer, many of my clients get frustrated when we say to them, oh, well, that's not relevant, or that's, we'll talk about that later, or, yep, I understand that, but it's not the right time. Whereas in mediation, really, that is their opportunity to tell their story and to talk about what's important to them, whether it's relevant or not. Now, there are limits, obviously. We try not to allow people to go on too long on a tangent, but often by listening and by giving them the space and the permission to tell their story and to tell us about what is really bothering them and really grieving them, we start to see creative solutions and options and ideas, and we can generate solutions that just are not possible if you stick strictly within the letter of the law and strictly within the rules of evidence. An example of that comes from my time at State Trustees. We had a family where the father died, leaving his estate to his wife, and she was his second wife. And he had 2 adult children from an earlier relationship. And they challenged the will because they felt it was unfair that the entire estate was going to the stepmother, who they didn't particularly like, which is often a factor in these types of cases. But this woman also had her own children from a previous relationship. And so the children of the deceased man were very upset that their inheritance was going to go in the first instance to the stepmother, who'd never been very nice to them, and then when she died, to her children. And they really felt that they were missing out. And there was not very much prospect of them receiving anything from their mother's estate when their mother died. So it had that, and it was a small estate, and in estate law, our ideas of large and small are a bit different to, I think, the outside world. But there wasn't a lot of money involved. There was the house that the man and the stepmother had lived in, and there was a very small amount of savings and other cash assets. And the stepmother needed somewhere to live. This was her only real asset, and her only source of income was government pensions. So she didn't have a lot of assets or resources of her own. So she was defending the claim and saying, well, I'm the wife, I should be provided for. The law in Victoria says I should be provided for, and I need the entire estate in order to, support myself into my old age, and I need security and certainty of accommodation. I can't be homeless in my 70s. The children, as I said, felt that it was unfair that they would end up getting nothing from their father's estate and that everything would pass to their step siblings with whom they didn't have a relationship at all. After a very long, fraught, emotional day of mediation, during which one of the daughters got up to walk out and nearly left 2 or 3 times. We nearly had the whole thing fall down. But eventually, through using some of these techniques that I'm about to share with you, we were able to come up with a solution that meant that everybody's needs were met. The property was divided into 3 equal shares. The stepmother got 1 share. The 2 adult children got 1 share each. The stepmother was given a right to reside in the home and a right to use the 2/3 that belonged to the children for the rest of her life. So that meant she could remain living in the home, or if she needed to, say, move into aged care, she could sell the home and use the proceeds of sale to pay her accommodation in the aged care facility. And when she eventually died, each of the adult children of the deceased father would receive their 1/3 of whatever was left from that capital amount, and the other 1/3 would pass in accordance with the stepmother's will. Now, had the matter gone to court, the children would have got nothing. It is absolutely crystal clear that the application of the law would have meant that the stepmother got everything. But because we went through the mediation process, and because we took the time to understand what each party wanted and needed out of this dispute and out of this equation, we were able to come up with a solution that worked for everyone and met everyone's needs. And I'm going to show you tonight some tips and techniques to show you how you can bring a similar approach to your family law mediation. I'm going to share with you some techniques and strategies that I share with my coaching clients. And using these tools, by the end of tonight's episode, you'll be able to begin to look past the emotional trigger points and uncover the issues at the heart of the settlement process. You'll be ready to reframe and redirect the conversation with your ex, and you'll be able to move that conversation away from rehashing past grievances and onto a more productive, forward-focused path. You'll be able to find new perspectives on old problems and stay focused on the outcomes that you want. This will help you to avoid being distracted by an emotional ambush from your ex and to feel cool, calm, and confident for your next mediation session. Now, if you haven't already entered into the family law mediation system, you may not know that often the family law mediation is conducted over a number of sessions. Each one is usually between 90 minutes and 2 hours long. And you might have them once a week, once a month, or at other intervals that suit the parties. And often there are 3 or 4 sessions. That's usually how long it takes. But of course, every matter has its own complexities. Some take longer, some can be resolved more quickly. So what often happens, I find, with my coaching clients who come to me for family law matters, they're often actually in the middle of the process. So they've been to one mediation session and they're usually fuming over what the ex has said and what the ex has demanded and what the ex is asking for. And so they come to me after their first mediation session and before their second mediation session. And often a friend or family member has suggested they come along and do some work with me because they really are consumed with frustration and anger at whatever has happened. And working together, we move them out of that emotional space, out of that mindset, and we develop strategies together for them to take into the second mediation session to start to get things moving in a more productive direction. A lot of the examples that I'm going to be using tonight relate to couples with children. However, the principles and techniques are the same, whatever the decision that needs to be made. So I don't want you to think that because you don't have children, what I'm saying doesn't apply to you. It's just one of the examples that I will be using, and the underlying principles and techniques apply really not only in any family law dispute, but in just about every interpersonal dispute, whether it's in the workplace, in the neighbourhood, if you live in an apartment building like I do and you need to negotiate with your neighbours to, you know, turn their music down or not stomp around late at night. These types of tools and techniques are applicable. And just on that, I was having a conversation with a client today. We were doing coaching for her upcoming Fair Work Australia matter. And she has a conciliation conference coming. And I said to her something along the lines of, you know, you want the person from the employer to listen to you and to hear you. And she sort of said, well, why do I want them to hear me? And I said, well, because they're the ones that you're negotiating with. And she looked at me, she said, oh yeah, I forgot. I forgot that conciliation was not court. So I just want you to bear that in mind as we move our way through the next few slides. What we're talking about here is a process or a series of events, a series of conversations, a series of negotiations. Your aim during a mediation or a conciliation conference is not to convince the neutral third party that you're right and that your ex is wrong. Your aim during these conversations is to find a way to convince your ex to see things your way. You want them to open up to new ideas and new possibilities, and you want them to be open to fresh perspectives, and you want them to see the logic and the common and the sensibleness of your suggestions. You want them to feel that they're not so much giving up something as creating a win-win situation. And ideally, you want them focused on what they're going to get out of it in a way that means you also get what you need out of it. So, before the mediation, so a lot of what we're going to be talking about tonight is how you can prepare yourself before the mediation. And I suggest that you set aside some time for this 5 or 10 days before the mediation. Neuroscientists have found that it takes at least 5 days for our brains to build new synaptic paths. So when we start thinking about things from a different perspective, or we start thinking about new ideas, it takes about a week for that to solidify. So if you want to feel calm and confident when you go to your mediation, and if you want to have that cool, collected, composed exterior, you want the new thoughts and the plans and the strategies that we develop to have really settled in and to really have the pathways to have been established. So that's why I recommend you find time 5 or 10 days ahead of your mediation, so that when you come to mediation or conciliation, your synapses have adapted to these strategies that work through tonight. Now, some of what we're going to talk about tonight is going to seem a bit unusual, a bit unexpected. It's probably going to seem almost the opposite of what your lawyers have been telling you, and that's because I focus on very much on getting to the issues and the interests at the heart of the dispute. Now, that's different to a lot of lawyers. A lot of lawyers, and I know I used to do it too, a lot of lawyers focus simply or focus too early on the solutions. They want to tell you what the law says is likely to be the outcome. They want to say, according to the law, this is what you're entitled to. These are your rights. This is what types of decisions the court have made in the past. And that's fine, that's great, that's what your lawyer's there for. But my job tonight and in our coaching sessions together is to help you in a slightly different way, and to focus on the future and to focus on your ideal outcome and how you can get other people to share that vision for you and want to work with you to create that future vision for yourself and your family. And speaking of one-to-one coaching, I do have a special offer for you all this evening, which I will talk about towards the end of the presentation. So hang in there, and there will be a special offer just for you guys when we get to the end of our conversation tonight. So the exercises that I'm going to go through now are designed to be done with a pen and paper. Now, if you're someone who prefers to type, that's fine. If you want to use your computer, that's fine. But there is something very special, I think, about sitting with a pen and paper and writing things down. So that is certainly my recommendation. So set aside some time when you won't be disturbed. Switch off your electronic alerts and switch your phone to flight mode. Sit somewhere comfortable and well lit with a glass of water and a few snacks on hand. And I also find it's a good idea to have all of your paperwork with you so that you don't have to get up and go looking for them. So think about all the papers that you've filed with the court, if you've got that far, and you might not have filed with the court yet. You might be in the pre-court filing stage. That's fine. Bring together your bank statements, a list of assets if that's relevant, the kids' school schedule, your schedule, whatever is relevant, whatever information you're going to need to make decisions around this dispute. Have them there on hand so that you don't have to get up and go looking for them, and you can stay in the flow and in the moment. So the first question that I want you to think about when you're sitting there with your glass of water and your pen and paper is, what is this dispute about? And I want you to write out your story. And as I said, I want you to write it out longhand. How did you get here? What is the dispute about? Who's involved? Don't worry about the technical jargon or the legal jargon. Just write out your story on the paper. Who's involved? Who came? Who went? Who said what? How did you feel about it? When did it happen? Then, once you've got to the end of your story and you've sort of got it all out on paper, on a fresh page, I want you to write down what you are disagreeing about. And I want you to be specific. What is it that you cannot agree on? Is it a property division? Is it whether or not to sell the house? Is it whether or not you or your ex-spouse is entitled to some of the superannuation? Is it to do with the children, where they'll live, who they'll spend time with, what school they'll go to, what holidays they'll take? Is it a bit of both, or maybe it's something else? Whatever it is, write it down and be really specific about what you cannot agree on. Then think about if there's any aspects that you can agree on. So, for example, you might agree on what school your children go to. You might agree that the property needs to be sold, or you might agree that one of you will remain living in the property. So write down what you can agree on. So now we've got quite a comprehensive history of this dispute. We know the factors leading up to it, we know what it's about, and we know what you agree on and disagree on. Then on another fresh page, so turn the page for me, and I want you to think about what is the specific purpose of the meeting you're going to. So if it's a mediation, what is the purpose of the mediation? Is it to create a family plan? Is it to agree on the care of the children? Or is it to do with finance, assets, and property division? And again, write down all the categories that will be decided. Maybe it's both, or maybe you've got two mediations. Perhaps you've got one coming up that's to do with the family plan and one that's to do with the assets. Or maybe you've already got a family plan and you're having a mediation just to do with the assets. So identify and isolate what it is that you are going to be discussing at the mediation or the conciliation that you have coming up. And now we get to one of my favourite parts of the process. Tell it like it is. What is it that you want to say to the other party? What do you want to tell your ex? What do you want them to hear and understand? What do you want the mediator or the conciliation officer to hear and understand? This is where you get to write out all your grievances and all of your complaints. This is where you get to talk about all the things that the other person does wrong and how they tick you off and the way it makes you feel and the impact it has on you, on the children, on other members of the family, on your work life, whatever it is, get it down on paper. Write it down. Don't censor it. Don't worry about getting the spelling right. Just get it down. But, and this is important, this piece of paper or series of pieces of paper has to be put somewhere separate from all your other documents, because this is not a document that is going to be shared with anyone else. This is just for you. This is your opportunity to vent and to get it all off your chest. So we've now got a history of the relationship and the dispute and how we got there. We've really good, clear idea about the purpose of the mediation, what it is that you disagree about, and what it is that you can agree on, if anything. And now you've had the opportunity to vent about the other party. This is my other favourite question. If I had a magic wand, what outcome would you like me to create for you? So if I could wave my magic wand and create your ideal outcome, your ideal solution to this dispute, what would it be? Don't worry about the reality. Don't worry about how much money it'll cost or whether or not it's within the laws of physics. Just let your imagination run wild. And I want you to create a really vivid picture in your mind of what that would be. And write that one down as well. So we've got a really clear idea of what it is that you would love. If I could just wave my magic wand and create for you your ideal outcome, your perfect future, what would it look like? And then I want you to start teasing out each element of that. And I want you to start thinking about different ways that you could express that ideal outcome. So for example, one client that I work with is in the middle of a property settlement with his ex. They have a family plan in place, and now they're talking about how they're going to divide up the assets. And he came to me after his first mediation session and before his second. And he was very upset by things that the wife had said during the mediation session. And in particular, she had asked for 80%, that's 80% of the couple's pooled assets. And he was devastated. And he said to me, what am I supposed to do for money if she's got all the money? How am I supposed to provide for our children? How am I supposed to create a home for them when they come and visit me or come and stay with me? And together we started working on describing the kind of home he wants to create for his children. Is it an apartment? Is it a house? Is there a yard? How many bedrooms? How many bathrooms? How close is it to school? What other amenities are in the neighbourhood? Now he at this stage was living with a friend, so he was looking for a property to live in that was close to the children's school. And we were able to create a really vivid picture of the lifestyle he wanted to create when the children were staying with him. And from that, he was able to then work backwards and figure out how much money every week he would need to create that home for the children. And I suggested to him that when he goes back into the mediation, instead of saying things like, you know, how do you expect me to survive and what am I supposed to do for money and how am I meant to have a nice home for our children, start instead by describing that ideal vision. And we'll talk a bit more about how you present this during your mediation and how you ask questions of your ex-spouse coming up in a few slides. But really visualize what you need to do to create that ideal outcome. And then you can start to think about the practicalities. Maybe it's not possible to go and live on Necker Island, but maybe there is some other version that is practicable and that you can create. Think about who would be involved and what they would have to do, and how you would go about creating this ideal outcome. And as I said, think about ways that you can express it in different ways. So instead of saying, I want the children 3 nights a week, you might say, it's important to me that the children learn, spend time with me and my family, learn our cultural history, learn the language of my family, whatever it might be. Think of other ways that you can express what it is that you want and need from this arrangement. So get away from the solutions that we often talk about, which is how many nights we sleep where and who gets what asset, and instead start to talk about the underlying interests and the underlying values. So what is the world you want to create and how can you go about creating that? Okay, and then you do have to think about your ex, and I know that you probably don't want to, and I know that you probably want to avoid anything to do with them, but the reality is that if you're going to be successful at being cool, calm, and collected in your mediation, you're going to have to think about and anticipate and prepare for what they might say so that you don't get taken, you don't get ambushed, you don't get taken by surprise. And in fact, you can be the one who surprises them by being so cool and calm in your responses to what they say. So start by thinking, what if I asked your ex, if I had a magic wand, what's your ideal outcome? What might their answer be? And you probably know them better than most people. So just spend a moment thinking about what they might want out of this conflict resolution process. And are there any similarities between what you both want? So for example, going back to my client who has the children, he was fairly confident that the children's mother would want him to live close to school so that in an emergency he could be on hand and so that he could take them to and from school when they stayed with him. Although overnight stays on a school night was still an issue, he felt she could see the sense of him rather living close to the school. For example, he felt that it was appropriate that he have at least a 2-bedroom unit so that the children could have a room to share, but their own room, rather than say sleeping in a lounge room or sleeping in Dad's room. And we felt that she would probably want the same for her home when she's got the children. And a lot of the description that he gave me of the type of home she might want to create for the children was very similar. Backyard, close to the shops, close to school, 2 bedrooms at least. So are there any points that you think you might be able to agree on? And that's great, because if you think there are, you don't have to spend any more time or energy worrying about those. You can make a fresh list, put it aside, don't worry about it. And then you only need to spend time and energy thinking about and preparing for the points at which there is disagreement. In all of this, you may have noticed I'm encouraging you to look to the future. Things have happened in the past. We can't change them. When we think about the past grievances, past hurts, often it's very upsetting. We become emotional. We get drawn back into that moment. We get drawn back into that emotion. And we can't see the future. And we can't make good decisions because we are so influenced by our emotions. By looking to the future, we break that cycle, and you will be able to remain cool, calm, and collected because you'll be thinking about the future, which you can control. You can't control the past. You can only control your future. And as you'll see on the screen here, the more anger towards the past you carry in your heart, the less capable you are of loving in the present. So I want you to think about the present and think about the future. That's not to say that the past isn't important. The past is important. You have already written out the story and written out the venting of what, everything that your ex has done to upset you and pee you off. But in order to have a, oh goodness me, the word's fallen out of my head. In order to have a successful mediation, a purposeful mediation, a mediation that actually creates the outcomes that you want, you do need to shift your thinking towards the future and how you're going to create that future. So we'll spend a few minutes talking about what you can do during the mediation to help minimize the chance of being emotionally ambushed and how you can keep your cool. You'll see here an illustration which sets out the 6 stages of mediation. I'm not going to go into this in a lot of detail. The next episode of Ready2Mediate is on what you can expect at mediation, and we'll spend a lot of time talking about the process and going through the different stages of mediation. So this is just a bit of a snapshot for you, so you've got a bit of an idea of how it all flows. And as with most conversations, it doesn't necessarily go in a neat and tidy linear fashion. There's often forwards and backwards and ups and downs, but generally speaking, the beginning of the mediation process is about introductions and opening statements, setting an agenda, what you're going to talk about, exploring, figuring out what's really going on, and then beginning to generate and test options. That's when you begin to talk about the possible solutions. Whatever is agreed on, and we'll talk about this in a few minutes, whatever's agreed on is written down, everybody signs it, everybody takes it with them, and then it's wrapped up. And as I said earlier, some matters, this is done over the course of a day. So if it's a commercial dispute, or if it's a debt recovery, or if it's an estate litigation, for example, often this is done in one exhausting long day. In family law matters, and often in workers' compensation and work cover matters, and also Fair Work Australia matters, this is often done over a series of mediation sessions. So you might spend an hour and a half or 2 hours together every few weeks for 3 or 4 sessions until you have worked through everything on the agenda. So as I say, don't get too caught up in how that all works. We'll be talking about that in the next episode. So at the mediation, or before or after, if you're communicating with your ex, and I know some people do, particularly when there's children involved, do your best not to get dragged into rehashing past hurts. Redirect the conversation to the now and to the future, and feel the back of the chair. This is something I learned when I was doing my mediation training, and to be honest with you, it was an absolute epiphany. As a lawyer, my training for, as I said, over a decade was to jump in and find solutions and solve problems and tell my clients what they should do and give them the best advice and give them the odds of, what will happen if they do and don't follow my advice. However, in mediation, as the mediator, that's not my job. As the mediator, my job is to help you come up with your own solutions and your own options. And so what they taught us was that in that moment where, as the mediator, you want to jump in and give a suggestion and say, I know how you can fix this problem, what you must instead do is feel the back of your chair. Lean back into your chair, press your back into the chair, and let the conversation continue. Now, I'm suggesting that this is a great technique for you too. So, for example, if you're in your mediation session and your ex keeps complaining about something that happened in the past, and again, I'll use an example from the client I was telling you about earlier. His ex-wife keeps telling him he's not been a good father, he's not been a good parent. And his reaction, his gut instinct is to say, but I am, and to give examples that prove that he is. Now, I'm not saying he's a bad parent, and I'm not saying that those examples don't prove or show or demonstrate that he is in fact a good parent. But what I'm saying is that falls into the trap of looking backwards, and we want to look forwards. So what I suggest is, instead of defending and saying, but I am a good parent. Instead, ask the ex, what would that mean? What would being a good parent involve? How can I be a better parent? What would being a good parent look like? Can you give me some specific examples? Can you tell me? And you don't have to agree to do these things, but what it does is it resets their conversation and their thinking. And what it does is it interrupts their train of thought, and it makes them think about things from a different perspective. Now, when you're in the mediation or the conciliation, the structure is very important. So you'll get a chance to speak, and so will your ex. It's very important when they're speaking that you don't interrupt them, that you don't correct them, and you don't try and get them to change their mind at this point. What you want is for them to exhaust every complaint they have until they have nothing left to say. You want to sit calmly. You won't feel calm, but on the outside you want to appear calm, and you will be taking copious notes, and you will write down both what they're saying and what your reaction and responses are. So you're not going to forget it. You're going to come back and address it, but you're not going to interrupt them. You're going to let them have their say, and you will also have your turn to have your say. And as I said, when it is your turn, and if you are having a dialogue, a conversation, rather than just each of you giving your laundry list of complaints, ask them future-focused questions. So instead of talking about what you did in the past and what happened in the past and defending yourself, ask them, how would you like me to do that in the future? And as I said, this will disrupt that person's train of thought, and it will force them to think about their answer from a new perspective, because they've rehearsed and rehearsed and rehearsed what happened in the past, but they haven't stopped to think about how they want their future to look. But you have. You've done your preparation. You know what future you want. You've started creating those new synaptic pathways in your brain. And so you can calmly accept that, okay, the past wasn't perfect. I don't need to defend my past self. All I need is to come up with a way that I can get what I want and need from the future. Oh, look, we've already covered this one, which is taking notes, resisting the urge to interrupt. But do make notes about what you want to say, and take your time to go through those notes when it's your turn to speak. Agreeing to disagree. So as I said, a lot of these mediation sessions in family law matters are limited to about an hour and a half or 2 hours. There is no way that you and your ex are going to resolve every matter in dispute in an hour and a half or 2 hours. I really would be, if you do, drop me an email, let me know, because I will be surprised. So what you will do in your first and your second session is you will begin to identify the areas you can agree on and the areas you can't agree on, what is really in dispute, and what are some of the options. So there might be suggestions and ideas thrown around. Some of the answers to the what if questions or the how would you like me to do that questions, you're not necessarily going to say, all right, well, I'm going to completely change my personality and my behavior, but it will give you food for thought. So as I said, it will probably take 3 or more sessions to reach any substantial agreement. Always make sure there's a written record of any agreement reached, no matter how small. So if the agreement is what school the children will go to, make sure that's written down and everybody signs it. If there's an agreement that you will each go away and get a real estate agent to provide an evaluation of the property value on the market, make sure that's written down, and make sure that any agreement that you've reached is measurable and actionable. Who will do what? When will they do it? How will you know that it's been done? So if, for example, it's to get a valuation of the property, each of you is to send a copy of that valuation to the other 5 days before the next mediation. It's measurable, it's achievable, and you know whether or not it's been done because you either have it or you don't. Really important to set a time for the next session if you can. I know sometimes you can't for various reasons, but even if you can't set an exact time and day for the next session, I highly recommend that you set a on or before date. So you might say on or before the 30th of July, we will have our next mediation session. So that leaves flexibility around the exact time and day, but you've made a commitment to when the next step will happen. Try and keep these agreements to agree or agreements to disagree future focused. So again, try not to have things brought into this writing down process that relate to the past, because you can't change the past. Try and have them future focused. Make a note of any homework that you need to do. So do you need to get information? Do you need to make appointments with people? What do you need to do? Keep it relevant to the matters in the dispute. So this goes back to right at the beginning of the process, where you wrote down the purpose of your mediation. So if the purpose of your mediation is to divide the assets, then relevant to that might be things like the value of the assets and how you go about liquidating the assets, or how you might need to get finance in place to buy out the other person. Not relevant is things like, what holiday you're going on, or any of those sorts of things. So make sure that whatever your homework is, it is relevant to the purpose of this mediation. And if your ex is trying to get you to do something that is not relevant to that purpose, ask why. Why do we need that? How is that? Don't say how's that relevant, because that's quite emotional, but say, how does that fit into what we're going to do next time? How does that affect the future? Celebrate progress, no matter how small. So as I say, if you've agreed that the children will stay in the school they're in now, and if you've agreed that they will continue to spend one night a week with the father, celebrate that. Again, sit back, feel the back of your chair, look at your ex and say, hey, well done us, we've agreed on something. Well done us, we've narrowed the scope of our disagreement. Well done us, we've made a decision. So as I said, coming up in 3 weeks, and I'll share the information here in the showcase bar for you, coming up in 3 weeks is episode 2 of Ready2Mediate, what to expect at family law mediation. And that is where we will spend a lot more time talking about the process and procedure and how it all works. We will talk about phone mediation as compared to having everyone in the room, and a few different ways that can be approached. Now, if you have enjoyed tonight's presentation, which I sincerely hope you have, and if you feel as though it is something that you want to explore a bit further, you might be interested in a 90-minute one-to-one coaching package. So these are the packages. At the beginning, I was telling you that I noticed that particularly in family law and a few other areas, there is very few resources available, very few opportunities for you as an individual to have someone with whom to prepare for your mediation, and to bring someone into the mediation room with you who is experienced in mediation and conciliation, who understands how the law works and who understands how human psychology works, and to be there as a support person for you. And that is a service that I offer you. Because often, as I said, your lawyer may not be permitted into the room, or it may not be financially viable to have them there because they'll be charging you an hourly rate. So I've put together for you 2 packages, and you can choose either or you can take both. The first one is a pre-mediation package, and that is where you and I will spend about an hour and a half together talking just about you, your dispute, your family law mediation or conciliation. Together we will identify the issues in dispute and the purpose of the mediation. You will tell me your ideal outcome. We will paint a rich and vivid picture. We will prepare and rehearse your opening statement. Particularly in the first session, you will be expected to have a statement ready that sets out who you are, why you're here, what you want to get out of the mediation, and what you've done so far to try and resolve the matter. So I will help you prepare that, and I will give you the opportunity to rehearse that. So again, you've said it out loud. I will encourage you to rehearse it again at home. So as we said before, the synaptic pathways have begun to form, and when you go to say it on the day of the mediation, it's not brand new. Your brain will go, oh, I know this. We've done this before. And you will feel that element of comfort and calmness and readiness, because preparation is a huge part of feeling comfortable and confident, particularly in high stress situations like a family law mediation. Together during our hour and a half or so, we'll also develop strategies for responding to the other person's opening statement, to their positions and interests. So together we'll go through those exercises of what do you think they're going to want out of it, what do you think they're going to ask for, and how can you respond and avoid an emotional ambush. And we'll also together develop and rehearse a forward-focused questions so that we can turn it around. Instead of saying, well, how am I supposed to have my own home if you've got all the money? We can turn that around to, tell me about the kind of home you would like our children to live in with you, and tell me about the kind of home you'd like our children to be in when they come and stay with me. And also as an extra bonus, because you guys have been here tonight with me and have listened to the webinar, I'm going to throw in a copy of my Ready2Mediate Family Dispute Resolution Companion Workbook, which is normally $20. I'm going to throw that in for you for your coaching packages. The second package is a mediation support package, and that's where I will come with you to the mediation or conciliation. So if it's a face-to-face mediation, I'll be in the room with you, I'll be taking notes, and I'll be able to provide real-time strategies, coaching and support during the conversation with the mediator and with your ex. If it's a phone mediation, I can either be in the room with you or possibly on the phone, although that can be a bit difficult. So ideally we will be together in the one room. You'll be on the phone, you'll have it on speaker, and I'll be there again taking notes and providing real-time strategies, coaching and support. And I did promise you a special offer. My coaching packages, the 90 minutes, is normally $525, but as a special offer for you who have listened to the webinar tonight, if you book your coaching package with me by Monday the 13th of July, by the end of the day, so let's call that 5 p.m, let's call that 6 p.m. actually, by 6 p.m. on Monday the 13th, you will pay only $299. So that's a saving of quite a bit. I'm not good at maths, that's why I chose to be a lawyer, but you will save and you will get that price of $299, and that means if you want to book both, if you want to book in and commit to both a pre-mediation coaching and a support package on the day, that will be $299 for each of those two events. So you can book them both in now and take advantage of this special offer. You can call me or you can send me an email to book in your coaching package, and as I said, that offer's available until the end of the day on Monday, so that gives you a few days to look at your diary, figure out when suits you, and get in touch with me to make arrangements. Also, if you know that you have a mediation coming up and the date hasn't been set yet, give me a call, we can sort something out, because I don't want you to miss out on this offer just because your mediation hasn't been scheduled yet. So if you'd like some more information, if you'd like to find out more about what I do and how I can help you, and if you want to get access to some other free resources, come and visit my website, www.rcbmediationservices. Oh no, typo, how embarrassing. That should be rcbmediationservices with an s.com.au. I have shared the link in the showcase section of the webinar, so let me just see if I can find that. It is there. Let's have a look. So yes, there it is. And then the next Ready2Mediate session, the next episode of this webinar series is coming up on July 20 at the same time. Look, another typo. How embarrassing. This is what happens when people rush their slides at the very last minute. So you know what? I'm going to get rid of that and go back to our home page. So my website is www.rcbmediationservices.com.au. The next Ready2Mediate session is coming up on the 20th of July at 7 p.m. and it's Ready2Mediate, what to expect at family law mediation. I hope that you've enjoyed our time together tonight. Please do send me an email or leave comments on the event page if you've got any questions or if there's any topics that you would like me to cover in the future. You're always welcome to come by my website, take advantage of the various resources I have there, book yourself in for a consultation if you want to have a bit more of a chat about your personal situation. Thank you so much for joining me, and I look forward to speaking to you again. This has been Beck from RCB Mediation Services for Ready to Mediate.